Okay, I'm being told that we're now live on Facebook to whoever is trolling social media tonight. Um, Thank you everybody for watching or attending. And we are today going to be discussing COVID-19 in the courts. So we want to ask the question overall, although we're going to cover a lot of ground in different countries, whether or not courts have been too deferent in the wake of COVID-19 to protect human rights and the rule of law. This is an event that we're hosting as the International Commission of Jurists. I'm Tim Hodgson. I'm a legal advisor for the International Commission of Jurists on Economic and Social Rights, and have been very involved in our vaccine access advocacy and other COVID-19 response work. What we've done today is we've invited a bunch of really excellent guests who are human rights lawyers and activists from around the world. We have guests from South Africa, India, Nepal, Colombia, and working on Palestine and Israel to speak about how courts around the world have or have not responded adequately in the face of COVID-19. I'll be introducing the speakers as they speak, and they will introduce themselves a little bit more. But really, the mandate that we gave to all of the speakers was to address this problem however they really wanted to from the perspective that they come from. What you'll find interesting, I think, is that many of the speakers have chosen to address it in a similar way with, I would say, similar conclusions, although courts work differently in different places in the world. And maybe we can draw some conclusions and ways forward from that. We have first, as our first speaker, and we're giving all of the speakers 8 minutes. To the speakers, I'll wave you down when you get to 8 minutes. We want to have some time for people if they want to ask questions. And if there's not people who want to ask questions, I have a lot of questions for all of you. So don't think that that's going to change anything. But the first speaker that we have here is my colleague, Rocio Quintero. She is a legal advisor for the ICJ. She's based in Bogota, Colombia, and she is working on Latin America. So not only Colombia. What I think she intends to speak about today is mostly one specific decision of the Colombian courts in response to COVID-19. But Rocio, you're obviously welcome to speak about whatever you want. Rocio, I think, has a presentation, so if you want to share it or tell us a bit more about who you are, your work, you're welcome to do that too. But thank you for joining us.
Hello, everyone. Good morning and good afternoon. I think Tim have introduced me well. I work for the ICG for the Latin American program, and I want to discuss with you some landmark decisions that the Colombian courts have handed down. I'm going to share with you a presentation that I have to discuss this. So give me a second. So, as I said, I'm going to discuss some landmark decisions regarding COVID issues in Colombia. So when it comes to the role of Colombian courts and tribunals during the pandemic in Colombia, they have handed down multiple rulings, including rulings in favor of people in vulnerable situations, such as homeless people and also prisoners. As of homeless people, for example, and in a case, the Constitutional Court ruled ordered access to a shelter facility to guarantee the right to health during the pandemic. And in doing so, the Constitutional Court acknowledged that homeless people must have access to sanitation and potable water, as mentioned, to prevent COVID-19. And in relation to prisoners, in a case, it was guaranteed the right to visitings and have communication with family members. And in this regard, it was ordered virtual visits, at least one per month, until in-person visits are allowed again. So now I would like to discuss in more detail two landmark decisions handed out by Colombian courts and tribunals. The first one is related to older adults and a stay-at-home order. And that was issued by the national government last year at the beginning of the pandemic. So in March 2020, the government issued a stay-at-home order for people over 70 years. And it was established an initial duration of over 2 months, and it was prolonged for 3 more months. In general terms, the order allowed older adults to go outdoors only 1 hour 3 times per week. By contrast, a national quarantine that was established at the beginning of the pandemic had an initial duration of less than a month, and it was prolonged multiple times. But every time, conditions were analyzed and updated, and more exceptions were granted every time. In general terms, the quarantine regulation allowed people go outdoors 2 hours every day. As you can see, the order established more restrictions than the quarantine, and it was based only on age. The national government argued that the different treatment between older adults and the rest of the population was necessary because people over 70 are more likely to contract COVID-19 and die from it. Consider this measure unconstitutional, a group of older adults filed a constitutional action called Acción de Tutela, and they argued that the order was discriminatory and a violation of the right to equality and no discrimination. And they also stated that the order was a violation of the rights to health, work, freedom of movement, and older adults. The main argument of the constitutional action was that although older adults are at higher risk of developing serious illness from COVID-19, the order was not a proportionate and effective solution because older adults might live with young people who can infect them, and the other perpetuated the stereotype of older adults as no autonomous people, and the other didn't consider that some older adults are compelled to work because they don't have savings or a pension, and some have also an active role in their communities. In addition, it was mentioned that the order affected their dignity and mental health, and it was possible to implement less invasive health policies, such as educational programs, to promote self-care of older adults. The judges who dealt with the case on first and second instance agreed with the petitioners, and they ruled that the order was discriminatory and similar measures should be avoided in the future. This ruling is very important because it recognizes that older adults are a diverse group with different interests and needs. Now, to finish, I would like to discuss about a ruling related to no disclosure clause in COVID-19 vaccine contracts. In Colombia, as happened in other parts of the world, the national government has not made public any information regarding the acquisition process of COVID-19 vaccines. This means that there is no information regarding the type of the vaccine acquired, the prices of the vaccines, and the delivery dates. This situation led a private institute to request the government complete access to COVID-19 vaccines contracts. The government denied the petition, and it says the information was classified. Specifically, the government mentioned that no disclosure agreement was a request of the pharmaceutical companies, and revealed the information will be a breach of the contracts, and it would impair the national government's ability to negotiate with pharmaceutical companies. As a consequence, revealing the information would compromise the health and safety of the Colombian population. So to determine if the information was actually confidential, as the government argued, it was presented a judicial remedy called recurso de insistencia before an administrative tribunal. The tribunal rejected the government arguments and, among others, ordered the government to hand over copies of the signed contracts. The decision took, the tribunal took the decision based on those arguments, and two arguments, sorry. The first one was related to the right information, and the second one was related to the consequences of considering access to COVID-19 vaccines as a global public good. So related to the right to the information, the tribunal set out that, that the right to access information is governed by the principle of maximal disclosure. This means that as a general rule, all information held by public authorities should be accessible, and that limitation and restriction are only possible in very limited circumstances. Importantly, the considerations on the right to information were based on the Inter-American human rights standards. On the other hand, the tribunal also established that access to COVID-19 vaccine is a global public good, and this has multiple consequences. One of them is that there is a greater protection of the right to access information, and another consequence is that private interests of pharmaceutical companies must not prevail over general interests and human rights. In addition, the tribunal also highlighted that details of COVID-19 contracts have been publicized by several countries, and the release of the information encourages control over government actions and increases trust and transparency among the general public. It's important to know that the government has not complied with the decision, but because it's exhausted available domestic remedies. However, the decision is very important because it has a human rights-based approach. In particular, it considers Inter-American human rights standards. So to conclude, I think a general conclusion we can draw about the role of court and tribunal is that access to courts and tribunal is essential to uphold the rule of law and the protection of human rights, in particular in the context of public health emergencies and also in relation with people in vulnerable situations. That's it. Thank you very much.
Thank you very much, Rocio, and thank you for humoring us by speaking English to us. Unfortunately, we're not competent to hear you in Spanish, but one of the things that I'll just point out for now that's very interesting about that is that we'll see that there's two successful cases that are important that Rocio has spoken to us about Colombia. One of the things that's notable to me in that environment, and those of you who are familiar with the jurisprudence of the court in Colombia on socioeconomic rights, which is very progressive and willing to do things on the right to health, which, you know, even make flexible procedures available and things like that, is that what's noticeable is the cases that haven't been brought and that haven't been highlighted. And they're not the ones that I would have predicted at the start of the pandemic, but we'll get there. Both the decision on discrimination against older persons, which is obviously evident in COVID-19, and this really important decision on vaccine access, which we're trying to let more people in the world know about because it's not well known because it's only in Spanish, are going to be very crucial. So we're going to move on to our second speaker now, and I promise you not everyone is from the ICJ. We now are going to ask Misana Moreni, who is a lawyer at Adala, to speak to us about some sharp criticisms that Adala's research reveals about the Israeli Supreme Court. And what she might not say, or she might say, is that many of the cases that she will be discussing were brought by Adala and other partner organizations. So Misana, if you'd like to introduce yourself even further, otherwise we're really looking forward to listening to you. You have 8 minutes.
Good evening, everyone. Thank you for the invitation. So my name is Misana Moreni. I am in normal days, I'm a lawyer at the Land and Planning Unit. During the Corona, I coordinated the work of the organization on the COVID-19 issues. I would like to relate to the final, to the last part of the presentation of Rocio, as for the importance of the access to the courts during emergencies in general and health crisis in particular. And to add to that, that access is not enough. We need also the court that is willing to intervene and not taking a position of avoidance, as I will explain a little bit more about the situation that we faced with the Supreme Court in Israel. So at the beginning of the COVID-19, the Israeli court made it to the headlines as activist court that decided to ban the governmental decision from using mass surveillance by by the Shin Bet, the security intelligence. So this decision and these headlines were so different from the reality that we faced during this period. We, as a human rights organization that submitted during the first wave of the COVID-19, the first half year of the COVID-19, we submitted almost 10 different petitions dealing with different violations, severe violations of human rights. The petitions dealt with the access to COVID-19 tests in the unrecognized villages in Naqab and in the neighborhoods in East Jerusalem that are beyond the separation wall. We had petitions regarding the isolation facilities for women, Bedouin women in the unrecognized villages in the Naqab, petitions regarding protecting the rights of the Palestinian prisoners classified as security prisoners in Israeli prisons. Also petitions regarding access to distance learning for different vulnerable groups. Other organizations and citizens have had petitioned the Supreme Court as for trying to protect the rights of different vulnerable groups, elderly people, pregnant women, Palestinians in the occupied territories, Palestinian workers. All of these petitions, 88 overall, were dismissed by the Supreme Court. 85 of these petitions that have been decided were rejected or dismissed by the Supreme Court. In a report that is going to be published soon, hopefully every day now, we analyzed the work of the Supreme Court during what we call the first wave of the COVID-19. By the first wave, we relate to the period between February and August last year. In this period, the main tool that was used in Israel to deal with the pandemic and the emergency situation was emergency regulations that are made by the executive and not by the parliament, which in general raises a lot of questions about the separation of powers and the rule of the law, and the proportionality of the measures that have been taken by the executive. During this period, the first wave, we called it 88 different procedures were held, where petitions were submitted to the Supreme Court. As I said, 85 of them were dismissed. 70% of the petitions were dismissed without having a hearing even. A third of the petitions were rejected even without a response from the state. In such a way, so it's clear that there was access to the court and people submitted petitions, but the petitions were not actually discussed into depth by the court and rather were dismissed on technical issues, as I will explain later on, or very short decisions, normally 3 to 4 or 5 pages, not more than that, without having in-depth discussions, constitutional discussion about the human rights violations. In our analysis, shows that the Israeli Supreme Court had different strategies of avoidance, avoiding making any principled decisions and making any decisions at all. So at each time that the court had a chance to dismiss a petition, they will just dismiss the petition without further thoughts about the situation. For example, one of the major strategy avoidance that we saw was the extensive use of threshold grounds to reject petitions, mainly the argument that the petitioners did not exhaust the procedures vis-a-vis the authorities and did not give the authorities enough time to respond before addressing the court. While normally it's maybe a reasonable demand from the petitioners in a time of emergency where the regulations are temporary, it just means that by the time that the petitioners will exhaust the remedies, the regulations and will be expired by that time. The Supreme Court in many cases just waited to have the slightest change in the factual and normative basis of the case to reject it, even in sometimes when the changes were not major and did not change the violation of human rights. It was enough for the court to dismiss the case. Even also in cases where the change was not definitive and it was just a matter of time till a new violation of human rights will happen again, the same violation will happen again. Even in these cases, the Supreme Court rejected the petition. And if such a change did not happen fast enough, so the court will just ask the state to have updates and another update and the third update till such a change will happen, and there's excuse to dismiss the petition. In addition, there was another interesting fact that the court almost did not acknowledge in any of the petitions that there was a violation of a human right. So there was no constitutional discussion almost in any of the petitions that were dismissed. It was the court had a lot of faith in the state, and that the state is doing its best to have equal treatment to all the citizens and protecting the rights, and that they are doing measuring the steps all the time, but there was no constitutional discussion because there was no acknowledgement of violation of human rights. The only case rights that there was an acknowledgement that were violated were a more civil political rights, like the right of freedom, and even then, the discussion about the constitutional discussion was between the individual rights on one hand, and vis-a-vis the collective right to life. And in this case, not the interest for public health, but the collective right to life. In this case, it's clearly that the individual rights, any violation of individual rights is proportional. So these our main findings during an overview summary of the main findings that we had during the first wave of the COVID-19. I would like just to the end to clarify that I'm not only arguing that the Supreme Court, the Israeli Supreme Court, failed to fulfill its duty to protect the human rights in a situation of a health emergency, in times where such a judicial review and such a protection is so needed, especially because of the broad powers and given to the executive and the drastic measures that have been taken. I'm also arguing that this situation actually reflects the way that the Israeli Supreme Court legitimized human rights violations in general during emergency situation, and specifically human rights violation of Palestinian population during the security emergency. And as you all know, that Israel have been in an emergency situation, a security emergency situation since the Nakba in 1948. And this, what we saw during the COVID-19, is just a reflection of the way that the court deals with human rights violation in emergency situations. Thank you.
Thank you so much, Maisana. I think that the only standout thing that I want to highlight there, and you'll hear a lot more from the other speakers about emergency powers, but it seems that the Israeli Supreme Court is particularly experienced at doing what other courts around the world have now begun to do. And what's interesting to me is that there's something, as a South African human rights lawyer, which is very familiar in the particular creative form of legal formalism that the Supreme Court is adopting to not hear cases. And it is exactly the approach of the South African judiciary during apartheid to any case dealing with human rights and complaints about racism and violation of rights. So it's depressing, but it's very important research, and thank you for presenting it here, and we'll hear more about it in the discussion. So now we are going to move on. The order of our speakers, to remind us, I'm going to ask Dan next, and then Manish, and then Gautam. So we're going to be talking South Africa, then Nepal, and then India. Dan Mafora is working for the Council for the Advancement of the South African Constitution. And Dan is a South African, I don't know, can I call you a human rights lawyer and a critical scholar who has been very active in commenting on the comings and goings of the legal system during COVID-19 and has some strong opinions on it. Dan, we're looking forward to hearing from you. And so you have 8 minutes.
Thank you very much, Tim. So my presentation tonight is just going to focus on giving a broad overview of the approach taken by the South African courts in relation to challenges to the regulations that were adopted in response to COVID-19. So just a bit of context here is that when the virus first arrived on our shores, there was a contemplation, or there was an expectation rather, that the government would declare a state of emergency. Now, if you know, are familiar with South African history, you'll know that state of emergencies have a particular history, or we have a particular relationship and a particularly dark history with state of emergencies and how they were used under apartheid to further brutalize the Black South Africans under that oppressive regime. And so the government opted for a piece of legislation, emergency legislation that exists. It's called the Disaster Management Act. Now, obviously, a declaration of a state of emergency would have meant that the government would have a lot more power, that there would be a derogation from rights, as it were. But it also, a state of emergency also has some benefits or some safeguards to ensure that there is an abuse of power where it has been declared. And so there are requirements that a declaration be put before Parliament, that an extension of a declaration of a state of emergency must be approved by Parliament, or in terms of the Constitution, and it sets voting thresholds and stuff like that, or voting majorities. But the DMA, which is the emergency legislation that I spoke about, really pre-existed COVID, and so was invoked because it allowed the government to act fast and to, put measures in place in order to kind of try and contain the spread of the virus. But that choice to use the DMA instead of declaring a state of emergency resulted in, or led to, some interesting consequences that I don't think a lot of people expected to happen, in a sense that the legislation itself grants the government or a minister, a particular minister, some considerable power in deciding what kind of measures to put in place, and gives her the power to draw up regulations that then take the place or operate in the place of the law as it usually would be. And so what we find is that because the DMA was enacted, and specifically when you read it, you see that it was enacted with particular emergencies in mind. So there are provisions in the legislation about not allowing access to a certain area, or the transportation of goods into a certain area. And so it's almost like it contemplates something of a natural disaster in the way that we understand it, as opposed to something like COVID or something like a pandemic. And so the extent to which the regulations limited rights was something that I myself had never seen, regulations being used. And by regulations, I obviously mean that it's secondary legislation. It's not the same thing as an act or a statute. And so it's a power that's conferred on a minister to kind of supplement the main statute. And we saw a lot of the regulations that restricted rights, the right to freedom of movement, the right to freedom of speech, the right to protest, and quite in quite restrictive and substantive ways. And a lot of the challenges that have come before the courts were largely about, does the minister have the power to make these regulations? And under South African law, the South African courts recognize or have previously said that the power to make regulations is a form of or is a type of executive action that is, so they say basically that when you make regulations, what you're doing is you are implementing national legislation, and the implementation of national legislation is an executive function. So when courts review challenges to the making of regulations, the standard that they use is very differential. So most of the challenges were brought on a rational basis review. So basically what that means is you allege that, you know, there's no rational connection between the means that the government has chosen and the purpose that they seek to achieve. And all the government needs to do to disprove your case is just to say, we have one reason, we have one good reason. And obviously it's a very good reason to say we are trying to stop the spread of the pandemic. But framing it in that way means that, you know, ultimately every challenge based on rationality is likely to fail, because it's such a low standard that it is impossible not to meet. You'd have to, you know, try really hard not to meet the standard. And so the challenges that came before the courts were rationality challenges, which the government has won quite easily. But my sense on reviewing the cases that have come out is that the court, you know, is reviewing these regulations as though they were normal regulations, which they obviously aren't, because of the fact that they impact on rights so significantly. And that usually when regulations are challenged, it is more about, you know, the technical day-to-day machinations of the state, as opposed to encroachments into fundamental rights. The only one challenge that I have seen that succeeded in the courts was brought by tobacco manufacturer, British American Tobacco, and they argued. So earlier in the lockdown, what happened is the minister issued regulations that did not permit or that prohibited the sale of tobacco products, because the minister had said smoking leads or is likely to spread, is likely to lead to an increase in COVID cases. BAT brought a successful challenge in court, but they framed their challenge not as a rationality challenge in the way that a lot of other litigants are done, but they framed it as an attack on the constitutionality of those regulations insofar as they limited the rights of tobacco farmers. They limited the rights of users of tobacco products. And I think the other argument was that it was an arbitrary deprivation of property because obviously it had become unlawful to sell tobacco products and stuff like that. And that's the one challenge, or the one court case where we see the court engaging in a proportionality analysis, and eventually finding that the regulation, or the specific regulation, was not was an unjustifiable and unreasonable limitation on rights. And so that's the only case that we have on whether or not the measures adopted by government have been reasonable in the way that they've limited rights. But generally, the courts have been very differential in treating cases as though they were just, normal rational review cases, rational basis cases, whereas there is an argument to be made for a significant encroachment into fundamental rights that is unreasonable and unjustified. Thanks, Tim.
Thanks, Dan. I mean, if I just track the presentations we've had so far, when it came to Colombia, I asked the question about what cases have been brought at all and not in a court that's normally very activist. When it came to Israel, the question is, what ways did the court, while knowing that it had to answer the cases, avoid having to make a decision against the government? And in the case of South Africa, you've got what is sometimes called the administration of constitutional law, where challenges are being brought and decided on such a narrow basis that they're almost inevitably doomed. But in all three instances, you have many cases that you might have expected if you were 2 years ago writing a prediction about what would happen if there was a global pandemic, cases not being decided in the way that they are. And I think that's quite interesting. So thanks for the outlining. Also notable that the challenge to the regulations that succeeds is by a multinational tobacco company. So it's not really the type of litigant you would expect to be vindicating human rights or arguing to try and protect them. You'll see when we hear Gautam speak in a while, I think that there's some similarities in the government's response through a disaster management act in India, and then also something that he might say about the proportionality requirement and how it's been avoided by courts. But first, we're going to go to Nepal. We have a very active court, the Supreme Court of Nepal, in the context of COVID-19. Maybe I'll hear a different opinion from our speaker, Advocate Manish Kumar Shrestha. But in general, it seems that the court, to me from the outside, has actually been much more active in trying to make statements to protect human rights, whether or not that's been beneficial or not. But before he speaks, Manish has been responsible himself for litigating some of these important cases that he'll speak about. So we're very excited to have you here to be speaking about your experience litigating in the context of COVID-19 in front of Nepal courts. So Manish, it's over to you for 8 minutes. I think you're speaking, but you're muted. So we can't hear you now.
Yes. Namaskar. Namaste. Namaste.
Namaste.
Yes. Me, Manish Kumar Shrestha. You're listening? Okay. So here, Nepal's in this pandemic situation, we have little different experience on this issue. When the lockdown started from the 24th March in Nepal, there is no any proper plan and policy, no any idea to government, no pre-plan for this kind of situation in Nepal. So at first, the Nepali people realized that this is a simple flu. This is not a corona. No coronavirus is in Nepal. People think like this, and government also give information that this is a simple flu. It cannot happen any a big issue in Nepal. So after, when the rate of infected people increased, then Nepal government also realized, yes, this is something different than flu. And at the first, there is no any plan, and movement is banned. Just government have one thing to say, that government have only one procedure, that government can make lockdowns. Continuation of lockdown is the only tool, only means to control this pandemic. No, nothing another. No medicine, no what you call research, no plans before. So just continuation of the lockdown. In that time, there is a bands of movements, students, women who is who is working where the area they what you call stopped, they restricted as their working site. They can't able to go back their home. So in this time, the restrictions of airlines, what you call, and the migrant worker. The first issue of Nepal is migrant worker who used to go abroad for the work, and basically large number of people lives in India for the work, and people restricted what you call people uh, in the border area. They are in border area demanding to come back home, but Nepal government, what you call Nepal government, at that time there is a dilemma that what to do. If they come to Nepal, if they cross the border of Nepal, they can create a pandemic situation more large, what you call infected rate may be more. So at that time, there is no idea what to do. Court is also closed at that time. And we went to the court with taking the writ at Supreme Court. I went to the Supreme Court taking writ to release them in Nepal. But the administration of the Supreme Court is quite ignorant about that. They all also scared that what to do in this new situation. But the full court of Supreme Court played a significant role to protect the rights and economic and social rights, to protect the rights and to protect the justice of Nepali people and Nepali citizens in this pandemic situation. So full court make a decision that Supreme Court can hear the writ again, writ in the issue of the emergence of coronavirus and the issue created by the coronavirus for this emergency. And then we filed the writ in Supreme Court that to release the people in the border area. After Supreme Court hearing on that writ, that writ said that they take care of the people, food and shelter, and they have their babies, their childs, the elder people, and women. So Supreme Court give what you call instruction. Supreme Court give order to the government that you should have to protect the your citizen, take care of food, shelter, and make a diplomatic arrangement to release them to Nepal. So, and then there is no any idea of the quarantine at that time also. So release the people, keep them in quarantine, keep them safe, keep them safety, and then go, they can release to their home. And Supreme Court gives that an extraordinary what you call verdict using the Article 133 of the Constitution of our country, Nepal. And likewise, there are a number of cases in Supreme Court, the significant verdict, very what you call very initiative to the government, and government realized that to the people that Supreme Court, full court decision and the decision of the Supreme Court and the verdict of the Supreme Court make the government compelled to responsible and accountable to the people. And after that, government of Nepal, what you call, make an initiative to make a quarantines, to make a medicine, to make a proper health plan, to make a safety to the girls and women. In the quarantine, the poor management of the quarantine creates rape issues on the ground. At that time, the different newspapers and news articles, what you call, give notice to the government that there is a rape issue also. So for that protection, the protection of the woman and protection of the child, Supreme Court give the verdict that you should have to give the proper what you call safety and security management. And likewise, in the writ of in one writ, Supreme Court gives a landmark decision on the pregnant woman that right to safe motherhood, regular checkups for the motherhood, and helpline, quick response team, women and children who may be violated. So in the COVID lockdown periods, in the name of the COVID, in the name of the lockdown, in the name of the quarantine, these mothers are unsafe. So Supreme Court give the verdict that government should be responsible, government should look on these all issues. And there should not be hindrance to the enjoyments of the rights of the woman. Supreme Court give these kinds of verdict, and no violences to the woman and child, especially in the security of the woman. This is very what you call and in the writ of and next writ on the prisoner's right in this small country. I think there is I have a what you call data. 25,000 people is in a jail. So overcrowd management. Supreme Court give another verdict to protect these all prisoners, elder prisoners, and make a payroll system to protect their life, right to life, fundamental right to life, and dignity of the people should be protected, and dignity of women should be protected, right of child should be protected, and food accessibility should be available there. So in another read that Supreme Court give a verdict for the prisoners also, and there is the Supreme Court's verdict for the reform of old prisoner system of Nepal. And likewise, government had not paid much attention to the prevention of the epidemic. In this time, people feel helpless, and only one way for the people is to justice. There is one institution, Supreme Court, what independently give the verdict in the name of government that it should be responsible, like the budgets and expenses should be clear, and it should be what you call notified by people that there should not be corruption. There should be accountable and responsible expenses on this issue, pandemic time. And only 4% people is fully vaccinated till today in Nepal. Only 4% people vaccinated. And another phase of the another phase of the next phase of this pandemic, this corona pandemic 19 coronavirus, that I realized that there is a lack of oxygen, there is a lack of ventilators. Government doctors, civilians shouting that they said this is a failure of medical failureness. There is a lack of medical assistance, medical equipment. So I realized that if people die without these oxygens and ventilator, this is a kind of what you call this is a kind of killing people by state. This is genocide. So I realized that, and I go to Supreme Court against the government, filing the case to give the direction to the government. So Supreme Court provide a very important verdict on that issue. Supreme Court said that there should be basic health. There should be free on health. No people can die without oxygen. Good assistance should be established. And if what the procedure, what the plan and policies government is making should be given to Supreme Court within the 15 days. Every 15 days till the pandemic is there in Nepal. So, and no shortage there in hospitals, oxygen, ventilator, medical supplies, storage should be maintained. And Supreme Court gives a very important verdict that no leading to death person by lack of oxygen. If a lack of oxygen people die, then it's a kind of a massacre. Without oxygen, people should not die. And ensuring people infected admitted to hospital, no return to home due to lack of oxygen. Large number of people return to home due to lack of oxygen. So this should not happen. The court direct the government and make infrastructure and necessary arrangement for the local level people ensuring to the vaccination. And in this time, in this pandemic, Nepali people, some of elite people can easily get in all of the facilities, but in the remote area, they are today still seeking for all of these medical facilities and these. So Supreme Court give that there should be equal treatment. According to the Constitution of Nepal, there is equal treatment, equal health service to every people. So Supreme Court give a large verdict. Supreme Court have give, I think, in the 30 writ petition there by pleaded by different lawyers. I also involved in, at least I think I have involved in 15 writ. There my writ maybe five writ, which I am a first petitioner of that one writ. And today in this lockdown situation, government just made a high-level COVID control management committee. In the name of the COVID control management committee, they're just continuing the lockdown. In the first phase of the lockdown, people, people is in like a prison for the 2 weeks, 2 weeks and 3 weeks. Government have even not data that how much stock food they have. There is a woman, there is a child, there is a poor people, but government have not such kind of records. So after 2 weeks, when we entered in the court and court give the verdict that there should be there should not be scarce of food to the people. So numbers of verdicts given by the Supreme Court.
Sorry about this, but I'm going to have to ask you to wrap up and I'll ask you a question again in the question and answer session. It's all very informative, but we just need to wrap up now in a minute. Okay.
Yes.
You can conclude.
Nepal, judiciary of Nepal stands as the pillar of the justice of Nepali people. We are fighting, even in lawyers don't have pass to go court, to assess the court. All people are in a prison in the home. So at that situation, we some lawyers who are in access of the Supreme Court, nearby Supreme Court, our offices. So we pleaded for the rights of the people, and our Supreme Court is very sensitive in this issue and matured in this issue. Some critics said that this is beyond the capacity of the government. Government can able to provide these all of things, and they said that this may be the intellectual romanticism only. But Supreme Court, after the verdict and decision of the Supreme Court, government is compelled to provide these all facilities to the Nepali people. And Nepali people today, Nepali people are in same fight of the coronavirus as all world are fighting. But the situation is different. Here, no vaccine. Our honorable president gave letter to the different countries for the vaccines. So no competency for the vaccines in another country also. So Nepali private sectors also not interested to bring the vaccine. Private sector and government sector is trying to give the vaccines, and now we are in vaccination process. And Supreme Court another recently Supreme Court give the order that there should be preparation and plan for the third phase also. There may be third phase, and we should be very aware of third phase also. So these types of verdict for the prisoners, for the old age, for the woman, for the child, for the migrant worker, in each and every aspect of the Nepali people, citizen of Nepal, Supreme Court playing a very vital role to protect the judiciary and justice. And this is the one of the pillar which makes the people ensure that we have justice, will get justice, and Supreme Court hears us, and Supreme Court speaks for us. So people are in hope that we will come soon. We are free of coronavirus pandemic.
Thank you very much for that. So as you can hear, and Manish could have gone on for some time, in Nepal, the courts have repeatedly ruled in favor of people for a wide range of cases, including based on how the government should act and legislate, how the government should plan, how discrimination and disproportionate impact on people in different areas, rural areas, women, children, has its effect, and even things that are high political issues like what the type of response needs to be and whether there needs to be legislation and regulation. So really on that level, it's good. And one thing that I'm going to ask you about later, Manish, so you can prepare for it, is the effect is important, but the question is, how do we get the government to comply with rulings like this? And has there been success in the Supreme Court or in the context of Nepal for that? But thank you very much for your remarks. We're going to move over now to the last speaker, which is going to be Gautam Bhatia. But before I introduce him, please, if you have any questions, the people who have joined here, you can start writing questions and we will ask them. The idea is to have a conversation. We were running about 5 minutes behind the time that we wanted to, but to have a conversation with the speakers and ask questions and give inputs if anybody else wants to, directly after Gautam speaks. Gautam is very well known to anybody who has read about or written on Indian law of any kind. He also seems to moonlight as a constitutional scholar and academic on South Africa and Kenya and many other countries in the world. He is, amongst other things, a published author on Indian constitutional law and runs a blog, which I think that he can link us all to, which is one of the, in my opinion, the best way to follow the comings and goings of the Indian courts. So Gautam, welcome. We really appreciate you attending and making time. We know you came from another event. You've got your 8 minutes and then we'll move into a question session. So as I said, anybody who wants to type and ask questions, they can.
Thanks, Tim. So I'm going to sum up the responses of the Indian judiciary to COVID-19, spanning a period of roughly a year and a few months from the date of the announcement of the first nationwide lockdown on 23rd March 2020 to around now. By way of context, the Indian constitutional courts, the High Courts and the Supreme Court, are empowered to strike down legislation on the grounds of non-compliance with fundamental rights. And over the years, the Indian judiciary, especially the Supreme Court, has acquired a reputation of being activist, being interventionist, and actually intervening in areas of governance where it feels that governance is lacking, developing creative remedies such as structural interdicts, continuing mandamus, which means that you take a case and then you basically supervise the implementation of the order from start to finish, which in classical theory would be encroachment upon separation of powers. But the Indian judiciary has done that. So that's kind of the broader context within which we need to understand the actions or lack thereof of the Indian courts. So and listening to some of the other presentations was a familiar feeling, because much like in South Africa, the central government also invoked the Disaster Management Act, the same words, which is this act. Again, if you look at its history, its purpose was to deal with natural disasters like cyclones, earthquakes, localized in specific areas, not really a health emergency, a public health emergency. But there was a genuine issue here in the sense that in India, you can declare an emergency, but not on public health grounds. And so there actually isn't legislation or a constitutional provision that might actually empower the government to take steps in a public health crisis. That's why the Disaster Management Act was invoked. The problem is that once you invoke it, it effectively gives omnibus powers to the executive. There's almost minimal parliamentary oversight, and the provisions that allow the government to take various actions to deal with the disaster are very wide-ranging. So effectively, it becomes ruled by decree, which is what's been happening in India, both at the central government level and also at India as a federation, at the level of the states. So the central government invoked the Disaster Management Act, and the state governments invoked what is called the Epidemic Diseases Act, which is an 1897 colonial legislation, which again gives similarly wide powers. And one thing that was really characteristic of the Indian situation was how the rules and regulations issued under the DMA and the several state governments under the EDA used to just change, regularly, and often there would be just a lack of logic that would seem to attend these rules. So, for example, there would just be a complete ban on movement. But again, given that COVID-19 spreads, it's kind of it's an infectious virus. What, like, say if you're moving inside your own car, right? Like how that would impact the spread of the virus. So it wasn't explained. And again, it would just keep altering, and they would pass a set of rules. There would be protests, objections, and then it would change the week after, change again, and so on. So, and that's one of the dangers of the rule by decree without scrutiny. Now, because Parliament's role in something like the DMA is basically almost non-existent, that would place greater responsibility upon the courts, because one of the organs of state is effectively not involved, right? But at least in the beginning, the Supreme Court's response was quite differential and quite muted. It was really summed up by the fact that the then Chief Justice gave an interview where he said that the executive has the 3 M's: money, material, and men. And, Indian judges have a habit of saying these kinds of things, and therefore, like, it's the executive that should really be tasked with the governance of the pandemic. Now, no one disagrees that the executive is obviously the correct body to manage the pandemic. The issue, of course, is that what do you do when executive passes rules that infringe on fundamental rights? And one of the really glaring instances was when the national lockdown, was announced with about 4 hours notice at 8 p.m. Announced for midnight. And then what happened was that because all businesses were forced to close, laborers who had come from Indian villages to work in the cities were suddenly without a job. And of course, they live from paycheck to paycheck. So they had no option but to move back to their villages. But they couldn't because all the transport had been shut down. So they had to walk. They had to walk on the roads. And when this was brought to the Supreme Court's notice, the Solicitor General of India said, actually, there are no migrants walking on the road. The court, despite there being evidence to the contrary, accepted that statement at face value, and in fact, kind of ordered an inquiry into media houses that were reporting this. So it basically became about the court impliedly threatening the media for reporting that migrants are walking on the road and not taking the state to task. That kind of summed up the Supreme Court's intervention in the first phase of COVID. The difference was that various high courts, when issues were brought to their notice, did actually do a lot more. So the Karnataka High Court, for example, state in southern India, ensured that internal migrant labor, was able to get back on chartered trains. Similarly, the Bombay High Court intervened on the pricing of N95 masks. And so various high courts did step up to an extent. That was broadly the first phase of COVID handling. And then the second phase that continued on until October. Then COVID seemed to recede for a while in India, and there was, things opened up. And then came the second wave, which was extremely brutal in India, starting in about March of 2021. 2 sets of proceedings took place then. One was an almost daily kind of proceeding before high courts on issues like oxygen masks not being available, oxygen supply not being available, hospitals running out of oxygen. The courts obviously are limited to the things they can do. So if there is no oxygen available, then a court order is not going to bring it out of thin air, right? So people did die because there was no oxygen. Hospital infrastructure collapsed. But at various points, the high courts again were able to just by asking questions and just by prodding the government, able to secure, for example, oxygen for a hospital 2 hours before it ran out by invoking Article 21 of the Indian Constitution, guaranteeing the right to life, right to health. And so that kind of day-to-day management happened a bit more in the second phase. The second thing, and I'll close on this, is that the Indian Supreme Court took cognizance of a set of issues in April of 2021 involving vaccination policy, medical infrastructure, and so on. The court initiated what in constitutional parlance is called dialogic judicial review. So effectively, it means that the court will ask the government questions about the vaccine policy. It will ask for information that the government might not be willing to reveal through Right to Information Act and so on. And using the information, it will bring out, say, possible arbitrariness, possible lack of proportionality, because that is the standard used in India, and so on. So we've had around 3 Supreme Court hearings in which the Supreme Court has deployed the dialogic form of review. One significant policy change, and it's arguable to what extent it's attributable to the Supreme Court order, but it did follow the Supreme Court order in terms of correlation, was that initially the vaccines were not free, except for a certain limited constituency of people. The government changed that policy, which it came soon after the court said it was prima facie irrational. So it's arguable to what extent there was a causal link, but it did happen soon after. So there is that important thing that happened. And the last thing, and the thing is, the Supreme Court has said that while in the beginning of the pandemic, when everyone's reacting, the executive will be given more leeway to devise plans and policies. But as the pandemic goes on, the judiciary should be more interventionist and strictly hold the state to account for constitutional violations. Where that goes will remains to be seen, because third wave will come at some point, and there's still questions about vaccination policy, vaccination pricing, and so on. So the questions are open, and it depends a lot on what will happen in the coming weeks and months.
Okay, thank you very much, Gautam, for that. I see that Tanvir has dropped off because of the fact that she had a power failure. So let me see if I can manage the Zoom. I don't know if I have those skills. Let me just say that one thing to point out now is that the last two courts we've spoken about in Nepal and India, some of the potential cases that have been made, decisions that have been made, have partially been made because of two aspects which are different about those courts. The one is that they have more relaxed processes for bringing public interest litigation. And the second is that they don't insist on writing full judgments in full and final detail on every single case. And the question that I have, and we'll come back to it now in the discussion session once we've dealt with the questions that people have, is to all of you, do you think that this type of thing makes a difference? So if we want to say that courts are there to hold governments to account, in the context of disasters, which we will see more and more as time goes by with climate emergency and things like that, do we have to relook at the processes that courts adopt and the ways that courts operate? And I wonder whether or not colleagues from Nepal and India might also disagree with me about the advantages of that. I know it's a debatable issue in India itself, the benefit of having the PIL process. But before that, I see we have a question from Nerima Were. Nerima has asked to all the speakers, how quick have courts been to respond to COVID-19 cases? This actually aligns very much with what I just said. Sorry, Nerima, for taking your point. Often the cases, I think Nerima is saying from the Kenyan perspective, are filed on an urgent basis. And have you experienced any delay tactics by the government and the Attorney General? So I'm going to give you all a minute to answer whether you have to say something about that. You don't have to all say something about that. Maisana, I think that you've already said what you had to say about it, but maybe you want to repeat in summary. I'll give you all a minute and then we'll go on to the next question.
Okay, so regarding the question, I will say the courts and tribunal in Colombia have responded in a very reasonable period of time. Actually, the problem here is about the implementation of the decisions. And in particular, I will say that it's common that the government question the reasonings of the courts and try to avoid comply with the decisions. And it's very common that say like, oh, actually the judges don't have the expertise to decide about this. So actually the challenge in Colombia is about how to close the gap, about having like beautiful sentences, respecting mention human rights, but in the practice, there is no correct implementation of the decisions.
Thanks, Rocio. Let's go to Maisana next.
Yes. So yeah, indeed, and what I said earlier is that the court avoided giving answers. This was the main trend or main attitude. But other petitions actually were pending for more than a year without getting where they are no more relevant anymore, and they are still pending for a decision. In any way, that's what my conclusion was, that the court was not able to deal with or not willing to deal with a changing reality from one day to the other. And in different cases during wars or different other urgent things, we saw that the court had hearings at night or from one day to the other. But during the COVID-19, it wasn't the situation. It was like giving a few days, sometimes more, to the AG to respond, and then having a hearing, or if at all, having a hearing within a month. So things are not that relevant, and everything was too slow at that period. As for the AG, we didn't have, and I can't say that they were having delay tactics. They were also on a shortage of manpower in general.
Thanks, Maisana. Okay, Dan, next. Is there anything you want to say about the speed of the South African court's responses to these reviews that you spoke about?
Yeah, well, obviously because of restrictions that are placed on normal activity, the courts have had to move, at least in South Africa, have moved to operating on a virtual level, and that has improved the way that cases are run. But I also think, to their credit, the government hasn't tried to kind of delay cases and render the questions moot by the time that they come to court. And what we've seen is, I think, of the judgments that I read, they were heard about a month or so after they were first filed, and then decided within 3 months. So relatively quick turnaround for South African courts. So I wouldn't say that there's been a purposeful delay tactics being employed by the government.
Thanks, Dan. So this is the, and actually one thing I'll add to that is that there was a stage at which the government had actually taken a blanket approach of settling cases, not on the lockdown regulation challenges, but they settled many human rights challenges in South Africa. But having said that, Dan indicated there's a few months that it's taken with some of these reviews. I wonder, Manish, when you're talking about all of these orders that you expressed the Nepal Supreme Court set out, how quickly is the turnaround from filing the petition to the order being issued by the court?
Yes. In Nepal, there is very quick response. There is very quick response of the court, and all people supporting the court system, and the attorney also supporting the court, because this is very common problem. At the first phase of this corona pandemic, we all are in dilemma that what should to do. Government imposed what you call lockdown, and we all are in home. So people could not come out. They don't have pass. They don't have what you call SS to come to the court. So after full court of Nepal Supreme Court, full court make a what you call decision. After the full court give a notice to the people that they can come to the court for their right, for their protection of fundamental rights, for their life and dignity. So when the first, after the first phase, after the first phase, it's very easy to file the case in this emergency of corona, and to protect the fundamental rights and economic and social rights for the issue of vaccine. This is very common problem to all. This is common issue to all for the protection of the child, woman, and new directives were new to what you call give order to make a new law compatible with the corona pandemic, because we have prevailing law is very old traditional model of law. So Supreme Court even give to the order to the government that it should be compatible to new issue like this corona. So there is no any dilemma. There is no any what you call now the Supreme Court and the management Supreme Court and the full court and administration and what you call attorney also supporting to give the justice, to provide justice, and government is compelled to fulfill the idea of justice to the people, the idea of the Supreme Court's justice.
Thank you very much. Gautam, maybe you can tackle this question while also dealing with Raul's question, which is...
Oh, yeah, I've seen that question. Yeah.
Okay.
So on the first one, I mean, in India, we have a term for this. We call it judicial evasion. The tax evasion, tax avoidance. We call it judicial evasion when the court avoids answering or deciding cases because it'll be embarrassing to do so. So in India, it's been a bit of a mixed bag. So you had the situation that, like I said, when the Delhi High Court was literally hearing cases, up till 2 a.m. in the morning, just to ensure that oxygen reached the hospital, passing orders every day, interim orders, like Tim said. And it was literally kind of like responding to crises as they happened because the infrastructure just broken down. So we had that. I think we also had judicial evasion as well. Like an example that still I find I find really bad was that one of the things that the government did was that among the many other rules that it passed under the DMA was that it required that laborers be repaid for the kind of work they had lost for around like 50 days of the lockdown. The Supreme Court stayed that provision and then said we'll hear the case 8 weeks later, and then never heard the case. So effectively, without a judgment on the merits, the one provision, the one rule in the DMA that was the benefit of the most vulnerable and marginalized people was effectively just made redundant by the court without a reasoned judgment or actually a finding of unconstitutionality. And that was literally the only rule in the DMA that the Supreme Court stayed. So I think you also have those kinds of situations where the court has done these things as well. I think it segues into answering Rahul's question about the bounded deliberative approach the Supreme Court adopted April onwards. Now, I think first of all, it's the correct approach. I mean, for a public health crisis where ultimately implementation has to be done by the government. There's only so much a court can do, and just passing an order saying let there be oxygen is not going to give you oxygen, right? So ultimately, you have to there has to be this kind of dialogic review and the bounded dialogic review. The question of whether it has succeeded or not, I think the jury is still out on that, because what has happened so far has been one significant policy change that came soon after the court hearing, a court order. And so I think it's possible to say that the court order contributed to that, although of course we'll never know really what the reasons were. So I think it's safe to say that there was a non-trivial contributory role. But the rest of it, I think, is still very much open, because the Supreme Court has so far passed 3 orders implementing bounded deliberative review and kind of raising questions, asking for information. And I think it really depends on where this goes over the next few months. And we'll only be able to know if it was a success or a failure maybe a year or so later when we look back on it.
Okay, thanks. And as you said, it's interesting because the court has sort of warned that it might not be as different in the coming months. So we would hope that there's a progress with that. My question, just thinking when Gautam is speaking for you, Maisana, is when I heard you speaking about the court in Israel continuously following up with the government and asking them for updates, it sounds like they could be trying to pretend like they are undertaking some dialogic review process, as might have been happening in India, which Gautam is speaking positively of as the correct approach in a public health crisis. Do you think that the Israeli court might defend itself like that? And what distinguishes a positive dialogic approach from a time-wasting tactic, which you've described? I think you need to unmute, sorry.
Yes, now. Okay, so I should clarify that most of the times when the court asked for updates, it was updates as for the legalization, the work of the parliament. If there's going to be any law that will overcome the emergency regulations, where are you going with that? Do you still need some time to go forward with the laws? So it wasn't a kind of follow that will make sure that there is a real change. And in many cases, at the minute that we saw that there is some progress in the work of the parliament, the Supreme Court immediately dismissed the cases without giving any additional input to what kind of law should be there that can change the regulations. So sometimes we got the same emergency regulations with the same violations of human rights just as a law, and the Supreme Court just dismissed the petition without and saying to the petitioners, now you need a new petition should be submitted, without giving any input, even for a future scenarios about what are the limits, what you should take into consideration. There was not any kind of input given by the court to the executive or to the parliament for the merit of the regulations or the laws that are being promoted. So, in this sense, for us, it was clear a tactic to take more time and clear. For example, one clear petition was a petition for the prisoners' rights and preventing Palestinian prisoners that are considered security prisoners from getting any legal consultations or family visits during the COVID-19. And the case was pending for more than a year, and the court keep asking the executive for updates even after the regulations were already out of date, even after that the law that the parliament decided that there is no need for a law to exchange the regulations because the situation is in general is better and the visits were eventually back. But the court continued to asking for updates from the executive for a whole year. So it's more for us. It was more a tactics of avoidance.
Yeah, and I think that when you say that, then it reminds me of what Rocio said, but something that we might say about South Africa too, which is sometimes the long, eloquent statements about human rights are a bit becoming cover-ups for not actually protecting human rights, and courts are becoming clever at avoiding making decisions in less obvious ways, which that maybe the Israeli Supreme Court is scared that it can't possibly justify denying the challenges if it actually considers the substance of cases, which is very interesting about the psychology of judges in that position. Dan, if I can go to you, the question that I have for you, and this puts you on in the spot a bit, but you work for a very political organization. The South African Constitutional Court, for anybody who's paying attention to it, has not been unwilling to expend political capital recently. It's gone very far in exerting its powers, for example, in a contempt of court hearing about the former president who has been placed in jail now. But the South African courts, including the Constitutional Court, have dismissed many applications for challenges relating to COVID-19 in a seemingly very deferent approach. Why do you think it is that the institution that's the Constitutional Court has decided not to expend political capital on making far-reaching decisions that contradict the government in the context of South Africa, and is instead using it for these other cases?
So that's a very difficult question. Well, first, because we haven't had a case. I don't think we've had a case. There was the application by a family, the family of a man who was killed by the South African Defence Force. I think that was the first COVID-19 case that made it to the Constitutional Court. But that was dismissed by the court, and it went to the High Court, and the family was successful there. But obviously it was about the conduct of the military as opposed to the actual decisions that are taken by the government in terms of the DMA. And what I have noticed in the cases that I read is that courts are happy to say, the minister has information, the government has information from all of these committees, all of these experts, that informs the decisions that they make. And so we shouldn't get involved. We shouldn't, second guess the government. And that's fine in cases that involve policy issues, which the challenges about COVID-19 responses have not been about. So, for example, in the thing that keeps coming up in these judgments is the court saying the government is trying its best. You can never legislate for a disaster. This has never happened before. It's completely fine what they're doing. But these are the kinds of things that the courts themselves would frown upon if they happen outside of the context of a pandemic. And it seems that the idea is that they don't want to offend the executive or the government, or want to be seen to be taking decisions that they consider themselves to be properly in the domain of the executive, which is strange, as you said, Tim, because South African courts are generally very interventionist when rights claims are involved. And it took a multinational company raising very interesting rights issues to get the courts to actually consider the impact of COVID regulations on fundamental rights. And so the courts have been purposefully, I think, one or two of the other judgments was that the rights issues were in the alternative. So the challenge was to the minister's powers to do certain things, but then the alternative challenge would be to the limitation of rights. And the courts, just say, we've decided that the minister has this power, so we're not going to decide the rights question, which is obviously a copping out because it allows them to say, you didn't make the case, or we couldn't reach it because you argued something different in the alternative. So the court's reluctance to expend its political capital, the Constitutional Court specifically, has been quite interesting. But I'm also just not sure, like you said, how much of that is informed by their own anxieties, obviously, as human beings, and shying away from potentially being blamed later by the government, just saying, we tried our best, but look at the court said we were acting unconstitutionally, and so it might be self-preservation at some level, but yeah, it definitely is something that I think we should be interrogating a lot deeper in conversations about the response or the status of constitutional rights under a pandemic.
Cool, thank you. I'm just to signpost for you, we don't intend to stay until 7. We appreciate your time already. So, or 7 at least, our time. I'm going to ask the last question that I'm asking to each of the panelists. We've already started, and then I'll ask you all to close with whatever thoughts that you have. So just so you know where I'm going with this. Rocio, a question for you. And again, apologies for putting you on the spot. But it seems to be that with our work in Latin America, there is a common trend towards very major social mobilization over the last few years. And examples include Colombia and Chile, and this has happened at the time of COVID-19. What do you think is there any relationship between the relative silence of courts in Latin America on these issues and the social mobilization? Or do you think that those things are completely unrelated? Because I guess what I'm asking is, I would expect a court to be more activist, especially a potentially activist court, when there is positive pressure on the government from the public. So I don't know what you make of that.
Well, actually, I think the court have played an important role, but it hasn't been enough. I think, for example, in the case of Colombia, last year, the Supreme Court handed down a very important decision about the importance to respect the right to protest. And I think, for example, in the case of Chile, the court has been very active, but the problem is that we still don't have like a formula to implement those decisions. And this shows that the courts are really important, but have limitations. And we have to acknowledge that, like, they have a role, and I think the role is very important when it comes to justiciability of rights. And it's important that the court recognize that the rights have to be implemented, but at the same time, it's not enough if the social civility society having a role to try to force the government to do that, and also the international community. So for me, it's not like a problem of the court. It just shows that it's a complex problem that requires different actions, and courts only can have a very important role, but it's not enough to resolve the problem. But in general, I think my opinion is that the court have played a role and they know the problematic, but at the same time, there is no correct mechanisms to actually implement those laws, because I think in Latin America, the courts are very progressive. And a good example of that is the Inter-American Court. And in the reality, the decision of the Inter-American Court, even though it's a regional tribunal, in the reality, the implementation, I think, is about 30%. So it's just like we need to have faith in the courts and the role, but if we think that the court are going to resolve all our problems, that's not the case. But this is my opinion.
Okay, thank you very much for that perspective. Manish, I'm coming to you, and I'm asking you the question that I thought that I was going to ask you, which is on the implementation of judgments. So it follows on from Rocio. There's many decisions of the Supreme Court in Nepal in favor of people protecting rights in the context of COVID-19. But have we seen any of these implemented? And if you haven't, then what could you do about that?
There is a problem. Supreme Court have given very important decisions and orders to the government, but government is ignoring these all decisions, and media is there to follow the government that these all decisions are made by the Supreme Court, but the government ignoring the people, government ignoring the rights of the people, curtailing the rights of the people, curtailing the rights, the movements of the people, only lockdowns. No lockdowns is what is the solution for the this pandemic. So all of the in this all area, Supreme Court of Nepal give decision, make a special task team, quick response team. Likewise, there are numbers of orders given to the government, but government ignoring. In these situations, media of Nepal, Nepali media and the media personnels and media institution, what you call pressing to the government of Nepal that to follow the guidelines and decision and order made by the Supreme Court of Nepal. And likewise, high courts and district courts also orders different verdicts to the local governments also, that local governments also should be responsible. In this situation, government in Nepal, here is the political situation is also different nowadays. Just a government is changed, new government is formed here. So just for the establishment of their government, they focused on their political matters, not in the matters of people's this situation, this pandemic situation. So this is also another issue. So the stable, if their government should be stable, then they will listen to all the verdicts and they do the work as per the need of the people. But there is what you call struggle of the government here. So just a day before, we get a new prime minister in Nepal. So there is some problem in government also, and government ignoring the verdict, orders and decision of the Supreme Court. Media, people and responsible civil people are what you call making government compelled to implement the decision of the Supreme Court. In this situation, Supreme Court and the courts of Nepal, different level courts, high court and district courts also playing very vital role to protect the rights and freedom of the people.
Okay, thanks for that answer. Gautam, you'll be last with the question. And my question to you is about two of the things that have come up already, but I wonder if you have an overall perspective on what, if anything, that we've learned in India about the role of the Indian courts, especially in public interest litigation, and what it should be as a result of COVID-19 and what's happened. Are there any insights that you can give about that, if you were to give a perspective on what the court should have improved or could improve, but might not, what would you say?
Yeah, I think that it's a lesson both for India, but I think also beyond India. It is that I mean, COVID-19 is by all accounts, going to be the first of many pandemics that are going to, occur with greater frequencies in the future. I think I echo the point that I think it's first of all important to have a realistic view of what courts can achieve and what they can't achieve. So expecting the court to manage the pandemic and to solve the problems is unrealistic. I think there's something to be said for the much maligned idea of separation of powers. Because and often the court's interventions makes things worse, specifically in these kinds of cases. But that said, I think what's equally important is to really have. I think this is something that's been missing in the Indian context, is to have a firm set of principles that really kind of create the framework within which the court can and should intervene when it's clear that what the government is doing is either at a policy level or at an individual rule-based level violating rights. So at the individual rule-based level, right, you can just apply proportionality, in a straightforward way, and X or Y rule then is disproportionate. Certain restrictions on movement, disproportionately affect older people, disabled people. So you can do all that, while of course giving a little more leeway for a public health emergency, but still kind of applying the standards. I think that's one thing that should be made clear. I think the second and more important thing is at the policy level. And I'm just thinking here to the TAC decision of the South African Constitutional Court. I'm thinking of the time that the Colombian Constitutional Court basically engaged in a political economy analysis of the Colombian healthcare market. And understanding the solution is not an individual remedy, but a structural solution, and that the courts can have a role to play in those as well. So I think that, and in the context of COVID-19, huge issues with respect to intellectual property, compulsory licensing, and what role that's playing to basically exclude access to vaccines in poorer countries. And given that the IP regime is a legal regime, given that questions around compulsory licensing and so on can be analyzed in a legal framework, I think it's also important for courts to develop a set of principles that deal with the interface between things like the right to health, the right to life, in the context of access to medicine, access to vaccines within global pandemics. I don't think that's happened yet. We've seen maybe a couple of steps towards that when the Indian Supreme Court said that the prima facie the government's vaccine policy was irrational, but we need to see like a proper fleshing out of principles along the lines of what happened in TAC in the context of AIDS, updated for the pandemic age and for intellectual property. Because again, in TAC, the issue wasn't pricing. It was because in the beginning of the court in TAC says that the issue is not affordability or pricing, but we need to have principles for that as well. So I think that's something important going forward.
Okay, I think that if I were to say something to that, and I think it's very interesting what you said, is that it's possibly the fact that we are definitely having to admit we probably have been in a new stage of how constitutionalism operates for some time now. And we are probably having to admit as a result of the pandemic that if courts are going to be significant, we have to conceptualize and rethink their role, which means understanding the separation of powers in a certain way. And my feeling listening to all of you and reading judgments around the world is that this is young lawyers who are going to do it, because part of the problem with appellate court judges is that they learned about constitutional law and separation of powers often 3 decades before they apply it. So there's this lag that often happens conceptually, where you have people who are stuck in the thinking of 30 years ago when they're on courts. This is quite common. But with that said, because this is not a platform for me to speak about my opinions, I'm going to give you all 60 seconds maximum to say your final thoughts in closing, and then I'll close so that we can all go and do whatever it is we want to do. I'll start in the order of the speakers. So Rocio, since you started, you go first. You've got a 60 seconds maximum.
No, I just want to reiterate that I think the tribunals at court have an important role in relation to fulfilling human rights. And as they mentioned before, I think established like standards and the way of how certain rights should be protected is very important, having an impact in the life of people. But at the same time, we have to recognize that the solution is not rely only on courts.
Okay, so Rocio going out on a limb in there against ICJ policy and maligning the courts. I'm joking. But Maisana, you next.
Yes. Well, actually, I liked your last comment about the judges and the difference between the conceptions and the way it's implemented in court. I think for me it's related along with the even attitudes of the court to social economic rights and the acknowledgements of what does it mean a violation of social economic rights during a public health crisis. And it's a question that I like, and it should be investigated more how the courts deal, which rights they deal more and which rights they deal less. And so yeah, while we're not expecting any salvation from courts, but it's still, they are playing a huge role in even in putting the limits and the road for the future, not only for the present.
Thanks, and everybody, just a reminder to look out for Adela's publication analyzing the role of the Supreme Court. The information she's given you already, it's really staggering how, I'll say it because it's my own opinion, how illegitimate the Israeli Supreme Court is, and how nakedly so. Dan, your last hot takes.
All right. Yeah, I just wanted to say thank ICJ for organizing. Learned a lot, and certainly some food for thought about the role of courts, especially now going forward, how that has changed, and maybe how to develop strategies around greater court intervention where rights are at stake in emergency situations. How and what lessons we can draw from how our respective courts have kind of approached judicial review, but also just what more they could do to have their orders implemented beyond just making grand declarations and statements and stuff like that. So yeah.
Great. Over to Manish, your 60 seconds. Yes, Manish.
Yes. At last, REITs are not only the solutions for this issue, and we need a broader grassroots advocacy, stakeholders, human rights protector, defender, media, civil people, intellectual people should come together to fight against this corona pandemic, to fight for the justice of the people. And these REITs are not only the final solutions. Orders of Supreme Courts, given by the orders of Supreme Court, it is respectable. But for the implementation of these orders, we need a broader grassroots advocacy.
Thanks. Yes. Spoken like a true activist, and I think that we will all agree with you here. Gautam, your final thoughts?
No, I think I'll just take what I said at the end of my last round of comments as those thoughts. I think those would serve as a good closing for me.
Okay, thanks. So then what I'll say just to close is first to thank all of the speakers for coming. We appreciate the time. And I've actually been even worse as a chair for those of you who are watching this and listening to it who aren't speakers. I've also asked all of the speakers to write blogs and given them timelines on it. So you will see that our speakers will all be publishing blogs on the Opinio Juris website next week. So you'll get to hear their thoughts said in writing in more detail and be able to hear about all of the cases that they're referring to. From my side at the ICJ, one of the things we're trying to do to be relevant in our COVID-19 response is precisely to try and work out what's happened and work out the role that the courts have played and the role that the courts could play. And one of the things that we feel is very important in these discussions is speaking to people outside of our bubbles and speaking to people outside of our contexts and our countries and learning from them. So we hope to be able to spread this webinar around. We will link to it on all of the blogs that are published next week on Opinio Juris, so look out for those, and hopefully have more discussions on this. But we really appreciate the time of all of the speakers for contributing to this and really giving your energy to it. Hopefully, we're going to be able to find a way to try and at least develop a way that we think courts should operate in future disasters and emergencies, which, as everybody has said, are no doubt forthcoming. But other than that, have a good night or a good day wherever you are. And thank you very much for participating. I'm going to click off the record.